Okay, well, thank you very much everybody for coming to, I guess, the second last lecture of this year. Next week's lecture is going to be on the history of Hempology 101, which has been quite exciting. In fact, we'll probably even just spend a lot of time reviewing what's happened in the last year. It's been such an exciting year for us. But today's lecture is on Health Canada and the MMAR. Although that has changed somewhat, because when we put the lectures out at the beginning of the year, it was only the MMAR. Now we have the Marijuana for Medical Purposes regulations, which changes the game. And so I'll be talking first about the old program and then shifting into the new one. But certainly Health Canada is the focus of today's discussion. And so I'll start talking about the MMAR, just I guess briefly summing up why it is there. It began in some sense in the 1990s when courts, in particular with Jim Wakefield in Ontario, recognized that he not only had a medicinal need, but that an exemption should be granted in the relatively newly created Controlled Drugs and Substances Act. The Narcotic Control Act didn't have exemptions, but there's something called an Exemption 56 in the CDSA that allows the Minister of Health to grant an exemption for anyone or any body, like Insight in Vancouver has an Exemption 56. So anyway, the judge granted a few people this exemption process and told the Minister of Health that he had to open up a program to hereby grant such exemptions. In a different court decision, Terry Parker, it was decided that that system was unconstitutional and that the government needed to come up with a much better program for people that needed it medically. That decision was handed down July 2001. The Marijuana for Medical Access regulations were introduced. The MMAR at first had a whole bunch of restrictions around access in terms of the number of doctors that patients had to get to sign the forms. In some cases, in many cases, you not only had to have your doctor sign, but a specialist. And it was quite a cumbersome program for patients to go through with all the paperwork and such. And then the program allowed patients to grow their own, or to get what's called a designated grower to grow for them if they were unable to. And those were the only legal forms of cannabis at the time. Back to when the first decision came around, Jim Wakeford, Alan Rock was Minister of Health, and he announced, grand things were going to happen, and put money into research facility, Prairie Plant Systems, to grow pot in a mine shaft in Manitoba. And that was supposed to be used for research, and research only. Unfortunately, the only research that was ever done was on AIDS and back pain, both of which have been canceled now for probably 6 or 7 years now. Pretty soon after the Harper government came in, they ended all research. But initially, Prairie Plant Systems was only supposed to be doing research that would essentially prove or disprove any medical claims that were being put to it and make it legal.
So does that mean that the research that's been done more recently than that, I believe at UBC and here at UVIC as well, does that mean that that's operated sort of like outside of the law?
It depends upon the kind of research. Most of that would be studying other sources of cannabis other than Prairie Plant Systems. They may be using Prairie Plant Systems for some studies over at UBC. I don't believe so here at UVic. It is standardized and they have the THC contents and stuff down pat, so that may be the case. Although I do know that at UBC they developed a strain called chemo in the 1980s, and there's been a sort of underground medical marijuana program going on at UBC where they've been studying their own genetics and helping out cancer patients very discreetly, not publishing any peer-reviewed literature, just kind of working behind the scenes, trying to avoid all the politics and just kind of learn about it. I know they're not using prairie plant systems pot in their studies. So that's one of the reasons why we're so keen on having the UBC club there, is to kind of get more involved and engaged in what is happening. Because most of the research on cannabis that's being done is either being done on street cannabis, or in the United States, the National Institute of Drug Abuse, NIDA, has a research facility at the University of Michigan, and they grow a lot of very low-grade pot there, and any studies done in the United States are being done on that. Many speculate that the low THC content is intentional to minimize the health benefits that would come from using it. But it's still better than nothing. There are many, there's a handful of patients that use it down there from that supply. But yeah, so the prairie plant systems was supposed to be just for research at first, and patients were expected to grow their own or have someone grow for them. And so that initial program again was brought into effect in 2001. At the same time, dispensaries like the one I was running had been in existence. Ours had been 5 years old at that point. And so the majority of Canadians that use medical marijuana, continue to still use illegal sources. Now dispensaries might be helping between 50 and 60,000 Canadians. It's hard to know the exact numbers, though most clubs don't give them out. But there's likely about 1 million Canadians in chronic pain who could or would be using medical marijuana, and then another 3 million Canadians using prescription drugs for eating, sleeping, or other mental health disorders, all of which cannabis could be potentially beneficial for. So we've got, give or take, 4 million Canadians that could be using medical marijuana for their illnesses. It's hard to say how many hundreds of thousands already are. But again, I speculate that the vast majority of medical users in Canada are still doing it illegally. There's now about 30,000 patients that have licenses to possess or grow in Canada. So that number has grown substantially. In the earlier years with the MMAR, the numbers were very small. Doctors were very reluctant to sign. The Canadian Canadian College of Physicians and Surgeons.
Yeah.
Is that okay? They issued statements soon after the MMAR came out, advising doctors not to sign the forms, that there may be liability issues. A document came out soon after that doctors could sign that, and with their patients, that would waive them of any liability. However, concerns of liability issues have been a very useful strategy on behalf of doctors that are unwilling or to sign forms, that they might admit that it works for a patient and that they know it works generally, but concerns for their insurance have stopped many doctors from signing these forms. And so the initial program was very tough to get through, and a lot of people speculate the only reason that there's up to 30,000 patients now with these licenses to possess or grow is because a few doctors have really gone out of their way to help patients. They've specialized in this, and it's been something that many people have taken advantage of. Unfortunately, a few doctors seem to have taken advantage of the situation as well, charging somewhat extreme amounts of money to sign forms. Other doctors charge somewhat moderate fees, a couple $100, which is fairly reasonable. $150 is for some doctors as well, which, given all the paperwork and stuff, they're not being compensated for it by the government, so it really is a nominal fee. Other doctors are charging more, and again, kind of specializing in this field, which is why the numbers have gone up. It's not that there's a lot more doctors. I don't have the statistics in front of me, and unfortunately I should have brought that. But can look them up online. But it's something that, again, when the regulations came into effect, the only intent was for people to grow their own until the research was done. That didn't sit well with the courts, though, who have consistently, since 2001, struck down several sections of this regulatory scheme, and often when a compassion club is behind the case, the government has been condemned for not having a more accessible program that would allow for dispensaries to operate. The first such case was the Hitzig decision of 2003 that came after a raid at the Toronto Compassion Club, and the judge in that case not only struck down several parts of the regulations that made it more restrictive for patients to sign up, but also told the government that they had to allow for a legal source of cannabis other than patients growing their own, which essentially opened the vault of prairie plant systems. And from that point forward, patients have been able to buy from the government at $150 an ounce for relatively low-grade pot, probably such poor grade that most clubs wouldn't sell it even if it was in its bud form. But because of standardization processes, they've actually forced prairie plant systems to do a number of things, even irradiating it to make sure that there's no fungus in it. But they grind it up, including all the stem and leaf, to make it a consistent product. Apparently a bud itself isn't a consistent standardized medicine, because the leaf kind of on the outer edges of the bud will contain somewhat less THC than the inner core calyxes, which again would be different from the core stalk. So they have tried to grind it up, which has caused a number of problems. Certainly the moisture content is thrown off there, and if cannabis has too little moisture, it's actually harsher to smoke than with, say, like 10 or 12% water. And so it's seemingly ruined the essential oils in it as well, such that the smell of it isn't pleasant at all. Certainly for people that are used to the fragrance of the herb, it's quite disconcerting to see what they've done to this plant and pawned it off as medicine. It does have some effect. It's better than nothing, but it has historically had a taste that one might associate with being grown in a mine shaft where they mined uranium. It's strange to think that they grew a medicine in such a horrific condition. They did change that a few years ago. Apparently they moved it to a different facility and it's no longer in a mine shaft. Nevertheless, it doesn't seem to have improved the taste a hell of a lot. So it opened up the prairie plant systems vault, as it were. But it didn't, unfortunately, even though the court decision told the judges to make compassion clubs legal, it didn't do that. Subsequent decisions in Svetopolis in Ontario and Barron here in British Columbia with growers argued that the restrictions around the number of patients that could grow in one location and the number of patients that a designated grower could provide for, that they were too restrictive. And so the judges in each one of those cases struck the laws down, but judges can't write new regulations. They can't tell the government this is what you should do. They just can say this is unconstitutional. And so in the beginning, a designated grower could only grow for one patient. Actually, before Hitzig, they couldn't even make money. It was Hitzig that allowed them to be compensated. But you were only allowed to have two grow facilities in one location. So two designated growers could use one house, or two patients one house, but no more than that. The courts in Svetopolis and Barron struck down those sections. The court saying that economy of scale and really if the government's worried about diversion, it would be better to have all the grow ops in a handful of locations rather than grow ops everywhere. So the courts kind of recognized for a few reasons that the program was inefficient and ruled them unconstitutional. The government went around and made the most incremental changes possible. First, saying that I think they went eventually from 2 to 4 grow ops in one location, and a designated grower after the Barron decision could grow for 2 people as opposed to the 1. They were very incremental changes, not really, going to the heart of what the judges were saying. In both cases, saying that there needed to be these mass commercial systems that would allow for patients. In all of these cases, and including ours, I did a talk on law, so I'm not going to get back into it all. The government has consistently said that the program's good enough, that it works, it's better than nothing. Canada is the only country in the world doing this. That's the kind of rhetoric that they throw back at the judges to say, like, give us time, and the patient should be happy with this. Well, the patients haven't been happy, the judges haven't been happy, but the government keeps saying that the program's fine as it is, until this past year, when suddenly the government came up with an entirely new program. Now, we knew there was changes coming in the works. They announced changes to the MMAR. They said, they didn't say a new system was coming in. They announced that there were going to be massive changes almost 2 years ago, soon after the Matthew Murnaugh decision. Now, Matt Murnaugh from Ontario has been an activist for quite a while, and he had a case in regards to his medical use where he couldn't get a license, doctors wouldn't sign, and he had a lower court judge rule in his favor that the system was virtually inaccessible by the vast majority of Canadians. It's hard to say all the reasons why Health Canada came up with this new program. Well, it's not hard to say. It's hard to say which one was the most important. The court decisions kept chipping away, including our case, but that one doesn't seem to be addressed in this new regulatory scheme. But time after time, anytime a really good challenge was put together, where some quality expert witnesses were brought in, the government lost, and so the Murnaugh decision, I think, was one of the final straws where they realized they had to make a change. Even though they appealed the decision, and again firmly will defend in the Murnaugh case that everything's fine, they're obviously admitting that such wasn't the case. And so the other main factor, and possibly the number one factor for the government and Health Canada changing the current system, is pressure that's being put on by police, fire agencies, and municipal authorities, because the designated grower program has been in some ways taken advantage of, but in other ways was so poorly written in the first place that people couldn't help themselves, and the government should have expected it from the very beginning. But there has been a lot of advocacy from these various agencies, because they've been catching all sorts of people doing all sorts of things, growing beyond their licenses quite often. They've caught people stealing power for their legal medical marijuana grow-off. They've caught people in all sorts of other cases that do not make the program look very well. And I believe they set it up to fail. I would suggest that in reinstating the personal licenses to grow, which I think will happen through a court order again, like I say, the government's been ruled wrong time and time again. I think we can hope and assume they'll be ruled wrong again here, that patients should be able to grow their own. It's something that these various municipal authorities have got a lot of bad examples from designated growers that have allowed them to really put a lot of pressure towards the federal government. They've been very upset, for example, about not getting information about where all these grow-ops are. And so in the new regulations, as opposed to the old ones where the only way they could find out if somebody had a license to grow was if they called up the Health Canada hotline and said, we've got Ted Smith at 826 Johnson, does he have a license to grow pot there? And they would get an answer on the hotline. So they'd find out on a case-by-case basis after they'd have to provide a name and address. Under the new regulations, all the commercial growers will have to actually contact the police and city before they actually get the license from the federal government. And so there's no guarantee that that license will be issued. So for a lot of people, they'll be giving information up to fire, police, and municipal authorities with no guarantee of getting a license. Well, hopefully they will, but the concern has been for that information to be spread beyond the individual employees and agencies, so that each one of these cities will have a file with everybody's medical marijuana grow up and where it is and the names and all that information, and there'll be employees that know all that stuff. And so there's concern that that information could be up for sale or violated somehow, so that people could be exposed. Certainly
well, just a comment. I mean, a bunch of people's personal information, banking information as well, was lost not too long ago. I believe just a few months ago, when Canada Student Loans had a bit of a screw up.
Information is constantly being accessed by people that shouldn't be, which is why there's been a great concern for agencies other than Health Canada to have these files of information. And even Health Canada has had a bad record of keeping it to themselves. For example, when the first contract was put out for Prairie Plant Systems, or before they got it, the government tendered this contract for people to grow and do research. They were told that it would be kept private, that their application wouldn't be made public. It was slipped to the media though afterwards, and so after Prairie Plant Systems got the contract, everybody else that applied for it had their name released in the public, and they were getting all these media interviews. Why did you want to grow medical marijuana kind of stuff? And so there isn't a good history of making the government accountable for keeping information to themselves. And so there's but the fire chiefs and municipalities have gotten their way with these new regulations. Again, they were one of the main opponents of the MMAR, and so they're certainly happy with it. And so there's a lot of reasons to speculate why the MMAR are essentially being written out here. But now I'm going to shift gears to these new regulations, the MMPR, because that's the new game in town. The MMPR, I've referred to them generally as the good, the bad, and the ugly. And that is that the commercial scheme seems actually fairly good. Not great, but good. The bad is that dispensaries are being left completely out of the picture. And the ugly is that patients are really being stomped on with this new program, not only being...
it's all ugly.
It's all pretty ugly. Okay, I said it's good.
It's all ugly.
It's better than Prairie Plant Systems. Okay, Prairie Plant Systems is not only a poor strain that they've made available, but there's no choice. Oh, they have two now.
They
that's
have
right.
two now.
Very little choice.
Which strains are those?
They're just genetic numbers. They're not
Genetic
like Kush or anything like
sativa
that.
and genetic indica.
Lot this, lot that kind of thing.
Generic,
yeah.
I mean.
And so it's better than what patients can choose now. So like I say, the current product that's available is very low grade. It doesn't appear, and the final regulations come out next month. So what I'm going to say about the MMPR right now is somewhat speculative, because Health Canada's released the regulations for comment, but it won't be until next month that the final regulations come in. So, hopefully a lot of what I'm saying these new regulations are about will change here. But at this point, that it seems like that this is how it's going to work out. So, so commercial end works out fairly well. It's not perfect though. For one, they have advanced security clearances for the owners and major employees of the organization. it sounds like those advanced security clearances are essentially going to eliminate anybody that works openly in the medical marijuana industry right now that's not working strictly within the letter of the law. That is, anybody running a dispensary or working with a dispensary is not likely to pass this advanced security clearance. The writing of it is appears to have standards for the minister that are much lower than that of court. So, like, the Minister of Health, to deny a security clearance doesn't have to have proof of any illegal activity. They can just suspect, or you can be known to be working in the marijuana industry, and even without charges, they can deny the security clearance. We're going to test that. Actually, we're going to see if Gail can get an advanced security clearance with me being her boyfriend and all that. It's not very likely, and so it's something where a lot of people that work in the current marijuana industry are being eliminated simply because of their associations or work. Now, they could set up shell companies with their friends and stuff. There's ways lawyers can get away with these things. The advanced security clearance might just cost a lot of money for some people to get through in different ways and make them hire more employees to be in charge of the group. But the other parts of the program for producers seem fairly reasonable. The standards by which they're going to test the medicine don't seem as difficult as that for prairie plant systems. Like, they're not going to irradiate it. They're not going to insist upon grinding it up and treating it the same way prairie plant systems did. At least it doesn't seem to be that way. And it also seems as though each one of these companies are going to be set up with the means by which to test for THC and CBD content as well. And so patients will know exactly the content of those cannabinoids and what they're buying. And the other part that seems, okay, but still somewhat overkill, the security requirements for these new companies. You have to have somebody there 24 hours, or a security company managing the security end of things, with cameras and all this sort of thing, with fencing around the property. It's pretty close to what they require for pharmaceutical companies to make their products. So it's something that is financially restrictive to get it going. One of these facilities would likely cost a couple $100,000 to really have it up and running, and you'd need a little crew of employees to be looking after it. And so it's something that the regs. Yeah.
I just had a question. What would you like to say would be is their first priority? Would it be to set up these things for themselves, or take down the medical, some dispensaries like yours, stuff like that? Is it like I'm just wondering, what are they going to spend more money on, like setting these things up or tearing down what's already established?
Well, it depends on who you mean by they. The government, Health Canada, kind of wants out of this program. They want to downsize the number of staff that look after it, so that people won't be applying to Health Canada for a license anymore unless it's a commercial producer. So for Health Canada, they're downsizing and simplifying it for themselves. Less cost, less work, I think that the main incentive for that has been this constant harassment almost from the police and fire chiefs and municipalities to stop the designated grower program. I think that is their incentive more than like we can make money off of this. And I don't think dispensaries are really there in their thinking. Eventually they might hope they can shut us down, but we've been pretty much ignored in this. Mm-hmm.
I'm just thinking, seems to me like it would make so much sense to just have the medical marijuana programs be a provincial jurisdiction, because for one thing, the political climate in BC is different from the rest of Canada and certain other parts as well. And second, that it seems like that would be a way to.
That's a perfect lead into my next point, which is that there are mechanisms in place for dispensaries, retail operations, but they are provincially regulated, and that is actually also because medicine and healthcare are provided provincially. The federal government has certain regulatory obligations. But really, when it comes down to provision of healthcare, that's a provincial responsibility. And so that's something that is written into the rules. It's written in that a doctor, nurse practitioner, hospital, or pharmacy could have a retail operation if their province or territory has the regulatory mechanisms in place to do that. Now, here in BC, while the public's very supportive, the BC Liberal government are conservatives cloaked, and so they've been very opposed to any pro-marijuana ideas at all. Christy Clark and Gordon Campbell are like, no, federal issues, we're not touching it, kind of thing.
Ironic from the guy who got arrested for drunk driving in Hawaii.
No kidding.
Now, these new regulations not only change things, but the upcoming provincial election is also going to change the game here. Many of us are hoping that after an NDP government takes over, that they'll be willing to look at dispensary model and a retail model in the new scheme. In fact, we're quite certain that they will. What might be actually a real trick is at that point convincing them to work with dispensaries and allow us to buy from these commercial operators to sell to the patients. It might be that the provincial government works entirely in line with these regulations, such that a dispensary like ours would have to hire a nurse or a pharmacist to actually be on the payroll. According to the regulations, these dispensaries or retail had to be owned by one of a doctor, pharmacist, nurse practitioner or not, which virtually makes it illegal for a non-profit to have a dispensary, which doesn't make sense at all.
Do they specify what kind of doctor?
Well, like a regular
medical
general
versus
practitioner.
Yeah.
someone.
So not an alternative doctor.
Yeah, I mean, why
No,
not?
a doctor of medicine. Yeah. And so that being said, it's unlikely that the province would have time to put such regulations in place before these proposed regulations come into effect, which is just over a year. April 1st next year is when the switchover is to be fully done. And so it'd be hard to imagine the province getting everything ready beforehand to license us so that we kind of can move into the new program immediately. That being said, if things are working towards that with dispensaries like ours, we would hopefully not get raided in that awkward time period while we're still quasi-legal towards getting licensed. But there's no guarantees. So right now for dispensaries, it's really a awkward situation. We're wondering how it's going to work out, whether or not it might come to a point where we just decide that government's got a good enough program, we don't need to be there anymore. We're hoping not to get shut down by the police, but that is another concern. The extract issue, though, is something that our club in particular is holding out for as a way of proving the government's programs are still ineffective, because in the old regulations and the new, you still can't make cannabis resin or THC or any kind of extract from the product. So that's still in the new regulations, so we still plan on challenging that right through to the end. But yeah, for the most part, dispensaries aren't in it. What they're doing with patients in this new regulation scheme is quite abhorrent. Certainly taking away patients' rights to grow is dead wrong. I don't know how to say it otherwise. Okay. So like I said, the new program is dead wrong when it comes to what they're doing with patients in terms of taking away their license to grow or taking away their designated grower. I think that will be, I know that will be challenged. There'll be a lot of people that will continue to grow despite the loss of their licenses, and they will challenge these new regulations in court. Hopefully the courts will decide that people do have the right to grow their own, but there's no guarantees of that. We'll see how it goes. And so there's going to be some immediate effects even with these new regulations. Apparently, the way it's supposed to work is at the end of this month, the beginning of next month, they're going to come out with the final version of the regulations. Apparently, security clearances are already being given to some companies already. There has been a means to get some licenses to grow for research purposes, and some companies have already set up systems, using a bunch of lawyers and stuff to get it all happening. So when these regulations come into effect next month, they're hoping and should be able to apply for the license and pretty much get it immediately and have pot pretty much ready to sell very quickly. I wouldn't be surprised if by the end of April there was companies legally selling cannabis under this new system. I believe they're that close to being ready for it. Health Canada has admitted that as soon as these new cannabis products are available, they're going to adjust their price. At this point, they've been charging $5 a gram for their swag, and without changing the quality of it at all, they just figure that they can bump the price up to whatever else the other companies are charging, based on the idea that they're losing money now at $5 a gram and they need to make money, which is really sad for the federal government to be losing money on such a lucrative crop. But
aren't they going to lose money from like street dealers, because that's
at this point, no, it's got nothing to do with that, because they're losing money the more they sell with their prairie plant systems. So the less they sell, the less they lose. So actually, in the strangest way, people buying it off the street saves them money.
yeah.
So right away the costs for people in the current system are going to go up. So I think immediately people that buy prairie plant systems are going to stop buying it and buy it off these new companies to at least try what else is out there if the price is no different anymore. But anyway, the government will be issuing licenses to grow up until the end of September, and up until the end of September, all the licenses that are issued, basically from October or April 1st to September 30th, they will end as of March 31st, 2013. So everybody's license to grow will come to a conclusion on that day. And April 1st of next year is the first day these new regulations come into effect. As of that day, nobody will be growing pot unless they're a commercial producer. As of October 1st, they stop issuing licenses to produce, and apparently by that time they expect these commercial producers to be available, and so they're going to allow people that have a license to possess under the current system to buy pot off of these commercial producers without signing all these new forms for as long as a year or a year and a half. Again, the final details will come out next month. But they figure that everybody that's got a license now doesn't have to get a doctor to sign up until the program's been working for a while. They've got new forms for patients to sign as well. It's not something where you get a license for 10 grams a day for the year in the same sense. You have to get a license for a specific company. And if you want to try cannabis from a different company, I believe you have to go back to your doctor, cancel the original contract, give him 2 contracts, one to say, and you're not allowed 10 grams a day, sorry, you're down to 5 grams a day. So limits 150 grams a month, which is half what the average person now uses in their system. The average person now in their system uses 10 grams a day, and they're coming in and saying it's got to be 5 grams a day, you can't get more than that. And so the new thing would allow you to write, if you wanted to get it from 2 companies, the doctor would have to say 2.5 grams from Jeremy's Gold and 2.5 grams for Gail's Gold, and there'd have to be 2 separate forms for each different company. And so, and apparently you'd be able to buy, monthly off of those companies for a year, and then you'd have to go and get your, I don't know what to call it, permit or whatever, renewed every year. So it's quite a awkward program, quite different than any other. It will all be done mail order. I didn't say that specifically, but without having a storefront, that's their only other option. Which is quite strange. Like, they keep saying they want to treat it like other drugs. Well, other drugs aren't delivered through mail orders strictly. Other drugs are sold in stores where patients can go and talk to somebody physically in the pharmacy to discuss kind of interactions with other drugs, how to use the medications properly, and more
Little
information
things like
instead of
that,
just relying upon the internet. A lot of people don't have internet, especially elderly people that should be using these medicines. Like, they're the ones that often have the least access to information. So, so there's a number of disturbing things about the way that this is going to work, but it seems as though the government's going to force it through, because ultimately it works a little better than their last program. And so, it's not a good system by any sense, but it is somewhat better. But there's likely going to be both a boycott from the patients under the new or current program, and it seems a lot of resistance from physicians, because this new scheme, in the eyes of the physicians, puts more weight on their decision, because the current program, the doctor and patient sign it, and then it goes to Health Canada, and in theory the final decision is up to Health Canada whether to approve it or not. Now the onus is entirely on the physician, at least in their eyes. Even with these waiver forms, they're screaming that there's, it's not a prescription drug, which is another point, where they say they're treating it like other drugs. Well, other drugs go through a drug approval process. Other drugs are drugs, for one; they're not plants. So, but anyway, they go through a drug approval process, and then the company's got a patent for like 25 years for them to be the sole producer and distributor of that specific drug. Well, that's not what Health Canada's done here at all. Health Canada's licensing any number of producers. They've not put a cap on it. In their announcements, they said 51 for the first couple of years, then maybe up to 61. Well, I would suggest more that there's probably like 500 companies that are going to be starting up trying to get in on this new medical marijuana system, not 50 like they've said.
Yeah.
There are no limits on what any of them can produce as well, so there's likely to be a real glut on the market where all these producers are just looking at the amount of money that they can make and wanting to max out on it.
Sorry. I'm just wondering what, like, when you say companies, that could be like a huge corporation, but it could also be like a relatively small firm. Like, what is the lower sort of, I guess, maybe employee count?
Well, we looked into this because at one point, we were both thinking to get one of our growers for the Buyers Club a license, and then actually even Gail on her property. I would say that to build a big enough grow house, if you were to build it all as opposed to kind of renting one, you're talking about a lot more money. If you could just go rent a facility where it was already built, I would suggest that in order to meet the economies of scale, you're probably talking about 5 employees. You'd probably be selling a couple $1 million in medicine a year. It's not likely going to be something that smaller producers can get into, so it's going to be like a medium-sized business to a large business. There's a lot of companies across Canada and groups looking at this. There's a First Nations group in New Brunswick that's working with a large U.S. company that are going to be setting up a large facility. There's a jail in Ontario that people are considering. actually fixing up and turning into a medical marijuana grow up.
Yeah, wouldn't that be
Open up that
fucking
old, like,
awesome?
Labatt brewery or whatever it
Yeah,
was.
it's actually going to be a very competitive market to begin with. I know that there's millions of dollars being invested right now in the Sunshine Coast on this. I know the Cowichan Valley's lit up. There's a lot of people that are really itching to get in on a bigger legal market here, and they're going to have a problem because they can't advertise. And Health Canada has made it clear that advertising will not be legal. They'll revoke licenses and stuff when people get advertised. So this again, it's not like it's a regular drug. The way that you get a drug approval process, you get your DIN number, you can approach the doctors. You got all your science already, and the doctors can approve it because they know what the adverse effects are because they've got all this information that comes with the DIN application. In this case, having not become a prescription drug, doctors will just throw their arms up in the air and say, well, we don't know what this is or what any of these companies have to offer. There's going to be multiple strains. Companies aren't held to just one strain. You can have multiple strains. In fact, any company would be silly to just have like indica or sativa. They'd be, they'd want to have the variety so that when you got a script from a doctor, if you wanted to try a different strain, you wouldn't have to go to a different company. So they're all going to be going for like CBD-rich strains because they're all going to want to have something that has a very strong medicinal benefit but no high. And then they'll all want their indicas. They'll all want their sativas. It's going to be interesting to see how it all comes out. That's for sure.
Do you have any predictions, maybe, about like how then now this vested corporate interest, how it would like affect marijuana policy, not just medical as a whole?
Well, this is where I say to a point, and I'll just maybe end on this, that while most of these regulations are really ugly, there is some really interesting and good parts of it. We are creating a viable commercial medical marijuana industry here in Canada. There's going to be businesses doing things and banks and all this kind of industry stuff happening. It's another step towards legalizing it outright. And medical marijuana has been a good foot in the door, but it's only halfway. The rest of us can't be criminalized. And that's been one of the reasons it's fallen apart so much, is because there's been a lot of pressure from recreational users to buy from medical and to get into medical somehow so we get protection from the law, whether it's because we're a designated grower or whatever means possible. That's not going to change. We're going to have hundreds of companies growing far more pot than patients will be able to buy.
What are you going to do with it, right?
So there's going to be a
about
number of things that occur here that I think ultimately could just keep cracking that door open to the point where the society is going to go, well, why are we prohibiting this? Let's just let these companies sell to everybody else, because that's the next step. We're going to have all these companies with all their strains. They're going to be studying it, promoting it, and there's no reason to think that they couldn't be doing it to the general market the next day. Like medical marijuana is just the name; it's marijuana. So this is, I would suggest, for creation of an industry here in Canada, this is huge. This is incredible.
So much better. There's already getting so much interest.
Yeah. Oh yeah, like Ross Rigliati getting all his attention. It's like, go for it. Like there's a lot of interest now that before it was bottled up. There wasn't a way of doing business in cannabis that was legal on any kind of a large scale, where now it's like go. It's like this big green light happening. So, it is the good, the bad, and the ugly. So, and so thanks everybody for coming and listening to my rant. I guess one more to go. Have a great day. Smoke good, God.